Okay, let's dive into this. We're looking at the situation with the 14 officers caught in what feels like a really long legal standstill after that Privy Council ruling.
Right. It's certainly complex. And
Well,
we know you, the listener, have followed this closely and provided a lot of background.
exactly. So what we want to do today is really synthesize all that information you've given us. We're going to try and unpack three quite distinct issues here.
And crucially, explore the potential ways forward for each, especially focusing on the possibilities for financial compensation through the High Court.
That's the goal. So think of this as us trying to map out the terrain. We'll tackle, first, the original retrenchment of those initial 14 officers. Was it actually lawful? Second, we need to look closely at the judicial review process. There are some serious questions there, maybe even misconduct, right?
Yes, potential fraud and the Solicitor General's role definitely need examining.
And third, there's this other group, a second batch of officers, who are apparently told to wait, effectively blocked from registering their own dispute.
Which seems problematic in itself.
Very. So for each of these three strands, we'll discuss, the legal grounding for a claim and what steps towards getting financial compensation might actually look like.
Okay, let's start at the beginning then. The original 14 officers. These are the folks who initially went to the EPA, paid their dues.
Right.
But somehow their case got tangled up with this later list, the 42 officers list. What's the absolute core issue for them?
Well, based on the legal report you shared, the fundamental problem seems to be that their specific dispute, the 14 officers matter, might not have a proper legal footprint. It wasn't formally registered as their dispute initially.
How so? The EPA claimed they registered it, didn't they? Back in March 2014.
They did, internally, it seems. But the only registration that's, publicly documented and used in court is one from September 2014, and that one names 42 officers.
Ah, okay. And all the court actions afterwards, the special tribunal, the judicial review, even the Privy Council, they all proceeded based on that September registration, the one with 42 names.
Exactly. That's the critical disconnect. Their specific group, the original 14, weren't accurately represented in the formal process from the get-go, it appears.
So if that's the case, what does that mean for their claim of wrongful retrenchment? What legal arguments could they make in the High Court now, seeking compensation?
Okay, there are potentially two main avenues. First, constitutional redress. They could argue under Section 14 of the Constitution that their fundamental rights were violated because they weren't properly represented or recognized in the process.
So it's straight to the Constitution. Okay.
Yep.
And the second?
The second is a more, standard common law claim for wrongful dismissal or unlawful retrenchment. The argument would be that if the whole legal context was flawed from the start, based on the wrong group, essentially, then their retrenchment didn't follow proper procedure.
Right, because the procedure was based on a faulty premise.
Precisely.
And if the High Court agrees with either of those arguments, what sort of compensation are we talking about?
Well, it could cover a few things. Obviously, loss of earnings and benefits they missed out on.
Makes sense.
But also, potentially, compensation for the psychological stress and emotional toll of this whole drawn-out affair. And given the alleged flaws in the process, maybe even aggravated damages.
Aggravated damages.
Oh, yeah.
So for these original 14, if they want to pursue this, what's the immediate next step?
The recommendation seems to be filing a constitutional motion directly with the High Court.
Okay.
That motion would need to lay out all the evidence showing how their specific group wasn't properly accounted for in that crucial registration and the subsequent legal steps. And importantly, they'd need to name the respondents.
What would be?
RBC, naturally, but also the Ministry of Labor, and crucially, the Solicitor General's Department, given the issues that arise later.
Okay. That seems like a clear, if challenging, path for the original 14. Let's pivot now to the second issue, the judicial review phase. This is where it gets even murkier, doesn't it? With these allegations of misconduct, maybe fraud, and the Solicitor General's involvement becoming more central.
Yes, this phase is really complex. The core problem, looking at the analysis, seems to be the persistent focus on that 42 officer list, even when the real grievance started with the initial 14 who actually sought representation first.
Right. The focus stayed on the wrong group, potentially.
Yeah.
What are the specific red flags during this judicial review stage?
Well, there are several points that stand out. First, as we said, sticking with the 42 officer list when the issue really concerned the original 14.
Okay.
Second, you have the Solicitor General deciding to hire external lawyers, Jerem and Jardine, to represent the special tribunal. But there's a question mark over whether the tribunal even had proper standing at that point in the judicial review.
So why appoint counsel if their standing was questionable? That's a fair point.
Exactly. Then there's the EPA's alleged use of, let's say, questionable information. You mentioned conflicting affidavits from Clay Hackett and Thompson about timelines and this whole no branch board reason for dismissal.
Which feels like a pretext, especially if the focus should have been on the original 14 situation all along.
Right. And finally, there's the Solicitor General signing off on the appeal to the Privy Council. There are doubts raised about whether proper authorization for that appeal was actually obtained from the Court of Appeal first.
Wow, okay. Those are some pretty serious concerns about the process itself. So, legally speaking, how could the officers seek compensation specifically related to this phase, the potential misconduct in the judicial review?
Well, the main legal argument here looks like misfeasance in public office.
Misfeasance,
meaning that public officials, potentially including the Solicitor General, might have misused their power either deliberately or recklessly causing harm.
Okay.
And alongside that, they could again argue for constitutional redress, but this time focusing specifically on the procedural unfairness, the denial of a fair judicial review because of all these alleged irregularities.
Right, a constitutional violation based on the process itself and what kind of damages could flow from that.
Well, under the constitutional claim, damages could be awarded specifically for the harm caused by that flawed judicial process. But also, importantly, if misfeasance or abuse of power by state actors is proven,
yes,
they could ask for exemplary damages. These go beyond just compensation. They're meant to punish the misconduct and deter it from happening again.
Punitive damages,
Right.
essentially. Okay, so what's the recommended action to tackle these specific judicial review issues?
It seems a separate legal action is needed, a petition specifically targeting this alleged state legal misconduct.
Filed where?
Also in the High Court. And this petition would need to demand disclosure of relevant internal documents and communications, particularly from the Solicitor General's department.
Trying to get transparency on those decisions, like appointing counsel and approving the appeal.
Exactly. And maybe even seek a formal declaration from the court about the legitimacy or lack thereof of that whole Privy Council appeal process.
Okay, that's a second distinct legal strategy. Now, the third group. The second batch of officers, the ones who were apparently told by the Ministry of Labor, hold off, wait until the first case is finished before you register your dispute. Why was that advice potentially unlawful?
Well, based on the legal analysis you provided, that advice seems to clash directly with both the Industrial Relations Act and basic constitutional rights.
Oh, so?
Section 4B of the Constitution guarantees everyone equality before the law and equal protection of the law. Telling one group to delay their access to the legal process just because another case is ongoing, well, that arguably denies them that equal protection and their right to access justice promptly.
It sounds like it treats them differently without a clear legal basis. And the Industrial Relations Act.
Right. There doesn't seem to be anything in the Act that allows the ministry to just pause or delay the registration of a perfectly valid dispute simply because another separate case is pending. They have a duty to process these things.
So this second group, what legal grounds do they have to seek compensation for being essentially put on hold unlawfully?
Their strongest argument is definitely that violation of their constitutional right to access justice under Section 4B. They were effectively blocked, it seems, from using the proper channels.
Okay.
And secondly, they could claim a breach of the Industrial Relations Act itself, that the ministry failed in its statutory duty by giving that advice and delaying their registration.
Makes sense. And the potential compensation for this group, what could they claim?
Well, again, constitutional damages for being denied that timely access to the ministry and, by extension, the industrial court system.
Right.
They could also claim for the lost opportunity. Maybe they could have reached a settlement through conciliation much earlier if their case hadn't been delayed.
Oh, the chance for an earlier resolution was lost.
Exactly. And finally, compensation for the financial impact and, the stress and uncertainty caused by that specific unlawful delay.
Okay. And the immediate next step for this group?
Similar to the others, but distinct. They'd need to file their own third petition in the High Court.
Focused on the ministry's actions.
Precisely. It would need detailed affidavits, sworn statements from the officers involved, explaining exactly what advice they got from the ministry and how the delay affected them. The Ministry of Labor would obviously be the key respondent here.
And what would they be asking the court for?
Two main things. A declaration that their rights were indeed violated by that advice and delay, and an order for financial compensation for the harm caused.
Okay, so we've mapped out three separate issues, three potential high court actions. Is there a kind of unifying theme or strategy connecting these?
Absolutely. I think the common thread, the strategic advantage really, is that all three issues fundamentally point towards violations of constitutional rights.
Right. It keeps coming back to the Constitution.
It does. Whether it's the first group's right to proper representation and protection of the law, the questions around the fairness of the judicial review, or the second group's right to access justice, they all touch on these fundamental guarantees.
So pursuing these as parallel constitutional claims actually strengthens the overall argument.
Potentially, yes. It could paint a picture of systemic issues or a pattern of fundamental rights potentially being overlooked or infringed upon in relation to this whole matter.
Okay. So if these cases, or some combination of them, do proceed to the High Court, what should everyone realistically expect? It won't be quick, I imagine.
No, definitely not quick. The first hurdle will be the High Court looking at standing. Does each group have the right to bring the claim? Is the evidence solid? Are there issues with time limits?
Procedural hurdles first.
Right. There might be preliminary hearings just on whether the court will even grant permission or leave for the constitutional claims to go forward.
And the response from the state.
You'd have to expect denials of any wrongdoing. They'll likely argue the delays are the claimant's fault or that the Privy Council ruling basically settled everything. Standard defenses.
But the court could order disclosure.
Yes, if the claimants make a strong enough initial case, the court does have the power to order the Ministry and the Solicitor General's Department to produce relevant internal documents. That could be crucial.
And if, down the line, they are successful, what are the potential remedies?
Monetary compensation is the main focus we've discussed. But also, formal declarations from the court saying constitutional rights were violated, that carries weight. And sometimes courts might suggest broader changes, maybe procedural reforms or public statements.
Okay, so despite the current silence and the feeling of deadlock since the Privy Council decision,
yes,
what you're really saying is there are concrete legal avenues still open, specifically targeting these three different aspects of the situation, all potentially leading back to the High Court for financial redress.
Precisely. The frustration is understandable, absolutely. But the key is to see these not as one tangled mess, but as three distinct issues. The initial retrenchment's validity, the conduct during the judicial review, and the blocking of the second batch. Each has its own potential legal basis for a claim in the High Court.
Right. Understanding those distinctions is key to figuring out a way forward.
It allows for a more focused, proactive approach rather than just waiting. It gives a framework for potentially seeking justice on each front.
Okay, so just to recap quickly for everyone listening, we've identified these three core problems stemming from the 14 officers' matter. The original potentially wrongful retrenchment, the serious questions around the judicial review process, including potential misconduct,
right,
and the unlawful blocking of that second group of officers from pursuing their own dispute. And for each, there's a potential constitutional path to seek financial compensation via the High Court.
And hopefully this deep dive, using the information you provided, has helped clarify not just the problems, but the specific legal arguments and potential next steps for each. It's about moving beyond the surface frustration. Yes, it offers perhaps a more structured way to think about seeking resolution, rather than seeing it as one insurmountable impasse. It really highlights that even when things seem stuck, understanding your specific legal and constitutional rights can open up paths forward.
Which leaves us with a final thought, really. Even when faced with complex legal history, institutional challenges, and, frankly, long periods of silence, dissecting the situation into its core components and understanding the specific legal avenues available, well, that's often the most crucial first step towards actually achieving justice.